End.
Hello and welcome to another episode of Simplifying the Law. As you may know, or if you are new to the program, this is an initiative by the government of Guyana through the Chambers of the Attorney General and Ministry of Legal Affairs to educate you, the citizenry, on provisions within the laws of Guyana, new laws that are being enacted, and even legislation which may exist already. Provisions within these legislations, for example, penalties which they might contain and of which you may be unaware, or just generally what the law entails. As you may know, the government has a very robust legislative agenda. For example, this year up to August, when the National Assembly went into recess, 19 pieces of legislation were passed, and these are modern, complex laws which require some sort of technical expertise to explain and go through. So through this program, we hope to bring those experts to you for you to be able to understand through their analytical explanations what these laws entail. Every week we touch on a different piece of legislation, and we feature different persons, primarily from the Chambers of the Attorney General. But later on, we would have persons from the private bar, religious organizations, or wherever necessary to break down legislation for you. This is a program for the benefit of the populace. Not only do we go through penalties and what not to do or not to break the law, but this is for the benefit of you, because there may be some provision which may be to your benefit and of which you are unaware. There may also be a penalty provision of which you may be unaware, but as our Honorable Attorney General says, ignorance of the law is no excuse. So this program seeks to enlighten and educate. With me today, I have the Deputy Solicitor General, Ms. Deborah Kumar, and a State Counsel, Mr. Pierre Squires, from the Chambers of the Attorney General, who is going to help me to go through the Condominium Act. And this is a new piece of legislation passed last year in the National Assembly and enacted, assented to, and it provides for the development of condominiums and condo complexes in a regulated fashion within the country. As we have seen, given that Guyana is at this juncture of its development, whereby it's one of the fastest growing economies in the world, condo complexes are becoming more popular, and a lot more are being constructed, and this was a necessary piece of legislation to be updated because there was a prior act which existed. But without further ado, let me just ask my guests to introduce themselves. First, Ms. Kumar.
Thank you very much, Richard. My name is Deborah Kumar. As you said, I'm the Deputy Solicitor General at the Ministry of Legal Affairs and Attorney General's Chambers. As Deputy Solicitor General, I provide support to the Solicitor General, who I believe you had on your program. He was the first to appear, and to the Office of the Solicitor General. I work within the Advice and Litigation Department, and as part of the leadership there, I provide legal representation to the state, mostly civil litigation proceedings, and advice and legal opinions to ministries, government agencies, all under the guidance and instruction of the Honorable Attorney General, Mr. Mohabir Anil Nandlall, Senior Counsel.
Thank you. Pierre.
Yes, thank you very much for the introduction. Yes, my name is Pierre Squires. I'm a state counsel attached to the Attorney General's chambers. I work along with my seniors in handling many litigious matters regarding the state in which we sue and which we are sued, and defending proceedings and doing so many other miscellaneous matters in connection with my duties as a state counsel.
Okay, thank you both for being on the program today. So if we could just get right into the legislation with which we are dealing. So if you could tell me, what does the Condominium Act provide for? And tell us, what is a condominium?
Thank you for the opportunity to speak on this modern piece of legislation. I believe that it is timely, it is a comprehensive piece of legislation. It's on par with other jurisdictions such as United States of America, Canada, and our sister Caribbean territories which have condominiums. It is important now given Guyana's trajectory for economic boom, and it caters for the demands for better and improved housing and accommodation within Guyana. I say it's a modern legislation because, as you mentioned briefly, we have had on our law books Act number 4 of 1989, which is the Condominium Old Legislation, Regulation and Miscellaneous Provisions Act, which was repealed. It has been outdated, it has been proven ineffective, and that has been taken off of the law books. And now we have this new legislation, Act number 6 of 2022, which is a Condominium Act, up for discussion today.
Well, the Condominium Act, it's, as my senior had indicated, it's very transformative. It's new, and it has been introduced last year and passed last year. From the description of the Act itself, it provides for the vertical and horizontal division of property, of land, essentially. Like, for example, if a person A, they own a plot of land, that Condominium Act, this new Condominium Act, would allow for an easier division of that property if it is that person A is interested in turning this property into a condominium scheme. It would allow for an easier division of that property for different owners, let's say person B and person C, to own different units within that property that is now divided. So this law would cater for that easier subdivision of property, and it would make it a whole lot more simple. The process would be a lot more simplified. And the Condominium Act, really, it would allow, or the introduction of it, it would bring in, given that our country is now on a trajectory for growth, we would be seeing lots of expats coming in and having interested business here in the country. They would be taking part in various sectors to aid in the development of the country. So this subdivision of the property, or this allowance for condominiums, would make it easier for their accommodation in the country while they're here. And it could even be a good gateway for persons here, our citizens, to have their own property, a easier gateway to own their own property here in Guyana. So that could be a good alternative as opposed to buying a whole house and land, and they can easily get their own condominiums and benefit from the common properties and the amenities within the condominiums.
Okay, thank you both for those explanations. So you mentioned the prior legislation which existed before the 2022 Act. If you could just take us through the difference, so what is new or what is different between the two acts?
Okay, I would attempt to highlight a few sections which are important in the new Condominium Act 2022. Firstly, and most significant, is that Section 19 of the Act provides that the unit constitutes immovable property. So just like how my colleague Mrs. Squires was mentioning about persons having the opportunity to own land and building in Guyana, the provision of Section 19 of the Act squarely says that the condominium unit is considered immovable property. Now, this is important when we consider the 1989 Act had only provided for the Roman Dutch system of land ownership in Guyana, when in fact what we actually have in Guyana are two systems of land ownership which coexist side by side. Firstly, we have the Roman Dutch system of land ownership, which produces a transport, which is issued from our deeds registry. And secondly, we have the system of land registration, which produces a certificate of title, which is issued from our land registry. So, Section 9, subsections 3, 4, and 5 of the Condominium Act settle this and provides for land ownership to be by way of transport and certificate of title. So effectively, what took place was that there was an expansion of the application of the law to include the land registration areas, and that has been quite significant. The second aspect I wish to touch on stems actually from the first one. So there are the two systems of land ownership in Guyana, and by virtue of those two systems, there are two instruments of land ownership, which I just mentioned, the transport and the certificate of title. But under the 1989 Act, what the unit owner, the buyer, the purchaser of a condominium unit was given was a certificate of sale, which document was as good as a transport, but apparently not good enough, because commercial banks, for instance, were reluctant to accept the certificate of sale to be used as collateral for a loan or a mortgage. So you were stumped there. Now, pursuant to the section which I mentioned before, Section 9, subsection 3, 4, and 5, every owner of a condominium unit is now issued with a certificate of title or a transport, a document of ownership for that immovable property. I also believe that the aspect of insurance ought to be addressed for this reason. Under the Act, Sections 43 and 44 provide for insurance. And when there is a condominium complex, the complex is owned under the Act, privately owned under the Act. It's called a corporation, and that corporation is incorporated pursuant to the Act. My colleague will probably elaborate more on that aspect of it. So for the purposes of insurance, we have the corporation owning the condominium complex. So the corporation would insure the entire corporation complex, the condominium complex. And that insurance can be for flood, fire. Our act specifically says tempest, which are strong winds, and sea waves, tsunami. And now it provides also for the unit holder to apply for insurance for things and risks which are not covered by the corporation policy, their general insurance policy. So now you as a homeowner, you can insure, for instance, your personal property within your condominium unit, your furniture, your electronics, and you can also insure for improvements that you make to your condominium unit. So significantly, there are separate insurances. So there's no double compensation. And you're absolutely covered in the destruction of property. So you feel safe because the condominium owner, the corporation, would have, insured against the bigger disasters, so to speak, and you have all your contents and items within your condominium fully covered as well.
Okay.
And another important feature of the new act I wish to touch on, which I think is important, is mortgages. Because of the Guyanese society constantly doing business with the banks and so on, Section 11 of the Condominium Act is fundamental and phenomenal. It actually provides for units to be free from encumbrances. So these condominium units can be conveyed free from encumbrances. I will explain. I see you looking a little puzzled as if you're about to ask a number of questions. So let me attempt to counter that. Firstly, this is a scenario. So this huge condominium complex owned by the corporation, and the corporation has a mortgage on the complex. Now, you are a potential unit owner, you are a buyer. Now, if you have a cash price, you have cash, you're buying cash, you would now approach the corporation. What will happen is that the mortgage for your unit, let's say your unit is unit number 5 in a unit of 50 condominiums, you want to buy unit 5. The mortgage for unit number 5 is disaggregated or separated from the corporation's mortgage. When you pay for that unit cash, that cash goes to the bank and the mortgage on that unit is liquidated, and the bank would issue the requisite release documents and obviously adjust the corporation's mortgage so that what you get is a free, clean title. And by title, I refer once again to the transport or the certificate of title. Now, not everyone can afford cash price for a condominium. I certainly can't. But in the event that you want to apply for a mortgage or for a loan facility to purchase a condominium unit, in the same scenario, The condominium unit is owned by the corporation has a mortgage. Now, what happens is that it is permitted, the mortgage of the corporation is lifted so that you and the corporation can have an unencumbered sale. So the sale, the agreement of sale and so on will go through. After that, the bank now, because the corporation has a mortgage, obviously with a commercial bank. So as that bank would now adjust the corporation's mortgage and would put a mortgage now on the new unit, unit number 5, in your name. So you will have a mortgage now on unit number 5. So essentially what is fundamental about Section 11 is twofold. It would allow for clean titles to, of ownership to be issued, and it would also allow a purchaser to use the same condominium unit number 5 as collateral for a loan and to borrow, to buy. So I hope that was helpful.
Yes, that was. You want to say something, Pierre?
Oh no, it's fine. It's fine.
Okay. Yeah, that's very elaborate in your explanation there. Thank you for that. But throughout you've mentioned the corporation, or the basically the owner of the condominium complex. So, if someone wants to develop a condominium complex of their own and to sell units, how may persons go about doing so, and does the Act provide for this?
Yes, to answer this question, the Act does indeed provide for this. It's very comprehensive in the Act, the way it provides for the registration and the approval process of constructing and developing your own condominium scheme. Now, persons who are interested in developing their own schemes, they have to submit a declaration to the Minister of Housing and Water. And the declaration and the description. The description, yes. Those two documents should be submitted. And therein there should be so many other technical documents, so many other documents that would be required. But essentially, you need your declaration and your description of the condominium scheme. So, when this is submitted to the Minister of Housing and Water, they would have a month. So the Act constrains the Minister as well to respond to this proposal, including your declaration and your description. So it would constrain him to respond to that proposal. So you should be, once you're interested in developing your own condominium scheme, you should be expecting a response or an acknowledgement stating that your approval has been received. And there's also another process of the approval. So the minister would also have within 3 months from that date of the notification, or sending the notification to the person who is interested in developing their own scheme, the minister has to either approve or reject that proposal to develop the condominium scheme. And if it is that no response has been received within that time, within that 3-month time frame, the Act or the law would operate to say that the proposal would be assumed to be approved. So if it is that they don't receive that response, yes, they can proceed, or they would have an implied approval of their declaration and their description for developing their own condominium scheme.
Okay. So condominium complexes, sometimes they feature common areas. For example, a common pool which everyone who occupy a unit may share, or at least that is a notion. Is this the reality?
Yes, in fact, it is a reality because the condominium complex or the condominium scheme would normally have a number of features which make it very attractive for persons who wish to reside there or who wish to own it. First of all, it's gated community. They have lots of amenities such as pools, swimming pools, tennis courts, supermarket, all manner of things. But it is provided for under the Condominium Act, particularly under Part 3, which provides for this common property, patio areas, open spaces, and so on. So basically, this common property is not property which is described in the description which Pierre mentioned or the declaration and is outside of your unit. So it's property which you share with others. What is important to note is that under Section 27(1) of the Act, your ownership of your unit is not separate from your interest in the common property. So it provides for that. And there are situations where the condominium owner, the corporation, can set out from the inception within that corporation's declaration and description what the terms for the common property would be, whether, it would be, for instance, shared expenses and so on. But the act is very clear, it provides for that, and whenever you buy a unit, you have full access to all of what is known as common property which the owners would share and would enjoy as part of the condominium complex.
Now, as you've described that situation there, I thought of a scenario where so far we have established that when you purchase a unit, you own the unit.
Correct. But
now we have brought into the picture that there are common areas which unit owners may share. Now, I'm thinking, how do you deal with maintenance of such? For example, do I repair my unit and the corporation, as you mentioned earlier, the owner of the complex repair the common areas and we share the costs as may be set out in the terms? Or how do you deal with repairs, and does the legislation provide for this?
Yes, Richard. I describe this legislation as a comprehensive one. And in fact, it is so, because all of what you've just asked and described is provided for. For instance, under Section 45 of the Condominium Act, it provides for repairs. Now, the corporation, the owner of the condominium complex, is the one who will repair the complex and the units in the event of damage. They will effect the repairs. I want to distinguish now between repairs and maintenance. So, following Section 45(1) is Section 45(2), which refers to maintenance. So the general maintenance of the condominium complex, including the common areas, that is the responsibility of the owner corporation. However, the Act expressly states that the unit owner is responsible for the maintenance of the unit. Therefore, if you have a light bulb that is broken in your unit, please do not call on the corporation, change your light bulb. And for other minor maintenance works within your unit. Also, as I stated before, the description and the declaration, which you would sign on to by virtue of an agreement of sale, if you intend to buy a unit to live in a condominium complex, would have certain terms and conditions. Like, for instance, you can agree to pay for garbage disposal. You and all the other residents and other unit owners can pay for that. You can agree to pay for security, which is very important for the condominium complex. But generally, you are responsible for maintenance of your space, your unit, and the corporation takes care of repairs in the event of destruction of the property to the entire unit, the entire complex, including yours. But maintenance must be distinguished from repairs.
Thank you. Pierre, I don't know if you have anything to add to that.
Oh, no. Well, just that, well, with the condominiums, I think it's important because, well, when you think of a condominium and owning a condominium, it sounds a whole lot similar to owning an apartment. And persons may want to know, if it is that I'm buying a condominium or spending or purchasing it for so much money, why or what's the difference between doing this and paying a monthly rent or a small monthly rent every month or so, and owning my own or having my own apartment or leasing my own apartment? So, well, with these condominium schemes or with these units, when you purchase this condominium scheme, you own this unit. This is your unit. You would have a transport or a certificate of title as the owning document showing that you own this specific unit with its descriptions all lined out and put on that document. So it's easier for you to say that, oh, you own this property, as opposed to a lease or a rental agreement in which your name is there on an agreement, but you have exclusive possession to the property, yes, but it's not as though you own it as though you own a condominium. Mm-hmm. So that's one of the major advantages in so many jurisdictions that we've come across, that you own this condominium and you, well, with a rental agreement, you just lease it from a landlord. And there's the other advantage. I mean, it would depend on the condominium itself or the scheme itself. There would be so many amenities, common property. For example, if it is that a large condominium corporation is interested in developing a scheme here in Guyana, they can add so many amenities. For example, pools, gym memberships, gyms, and so many other things that persons or the unit owners can have a common share in and benefit from this common property. So that's a great and ideal advantage of having a condominium as opposed to a rental agreement or an apartment in which you have a rental agreement.
Yeah, that I think it was important to make that distinction between the condominium and lease, so the apartment, whether you hold an apartment, and that also made clear that if you own a condo, you can't be served with a month's notice and you have to vacate the premises. The premises is yours.
Yes,
in a nutshell, right?
Yes.
Okay, so thank you for that explanation. So we have seen an increase in condominiums being constructed in Guyana recently. It can be attributed to influx of expats in the country, to work. But Guyanese are also interested in owning these properties as well. These are attractive properties, and like you said, they have common areas such as pools and gyms, and so these are attractive properties, and Guyanese are also interested. But given that it's also a new area of purchase, basically, there must be some technicalities involved, and it must be a bit complicated. So how do persons go through the process of owning or purchasing a condominium unit and not get scammed, for example?
Well, I think Section 53 of the Condominium Act answers that and would give a person who has an intention to buy a condominium unit not some level of comfort, but a lot of comfort. I say this because what Section 53 provides is that when money is paid to the corporation, it must be held on trust in a separate bank account. That's the first point I wish to make. So the corporation must establish a bank account, and monies for the sale of condominium units must be held in a separate bank account for that purpose. Now, what is interesting is that it's held in that bank account until you get possession of your unit.
Okay.
Or if you wish to have some form of security for payment of your money. For instance, persons might want to have a promissory note executed, which can be subsequently revoked upon payment. Or if there is consent in writing by the buyer to hand over. And the handing over of the condominium unit would or ought to be expressly for the purpose that the corporation would use and utilize the money for the construction process. So that is kind of a restriction on where this money will go, and you have the power to release it. If you want to accept, so the money ultimately goes into a separate bank account. But if you choose to negotiate with the corporation or the condominium complex owner to say, well, look, I will accept a promissory note, and when I get possession, it will be cancelled or revoked. Or if I give you consent in writing, use my money, my deposit, towards the construction of my condominium unit number 5. I also want to go back to mention a particular section, Section 7 of the Act. Now, Section 7 of the Act is also restrictive. Pierre spoke of the approval and application process by the minister. So Section 7 states also that whilst your application for condominium complex is being, is seeking approval while it's pending, that period is usually a 3-month period specified in the legislation. During that time, the corporation can't start building. So not because you have an application in construction immediately begins and you start throwing up complex units. You can't start building. And it prohibits you from accepting money for the purchase of units. So you cannot do that until there is approval by the Minister of Housing and until there is registration of the condominium complex.
Okay. So that protects the consumer.
Yes.
Well, it is often thought that most, if not every legislation contains penalties and offenses. So are there any penalties or offenses within this legislation?
Yes, many, as you rightly outlined, many modern pieces of legislation should ordinarily include penalties for various violations. And as well, picking up from where Ms. Kumar had indicated, if it is that there is such a violation of this money held on trust for the purchase of this condominium by the corporation, they can be subject to a heavy criminal fine. I know even persons overseas who might be interested in buying their own units, they might be a bit reluctant to purchase it because they're not sure who this person is, or if it is that something goes wrong on their end, if they would be subject to any criminal fine. So yes, to answer that question or that prospective question, there is a criminal fine for the misappropriation of that money held on trust. And it would vary, but there are fines outlined all in the legislation. And there are penalties, for example, for repair and so many other things outlined in the Act. But yes, as you rightly outlined, this modern legislation, it does include many penalties, which would put it on a platform of being something very modern, something very accommodating to anyone who's interested in developing their own condominium or purchasing their unit and being protected in any step of the way of having their own condominium.
And you mentioned penalties in relation to repairs. So let's say, for example, I'm a unit owner and I'm dissatisfied with the state of the complex, for example. There's no running water or things are falling out of the ceiling or something. Are there any provisions which may mandate that the corporation or the complex owner do certain things to facilitate the comfort of the unit owner or so? Are there such?
Well, I think that was answered in the provision or by the provision which provides that the corporation ought to be the one effecting repairs to the entire complex and to the units. But save and except maintenance of your sole unit.
Right. Okay. Well, thank you both for being here today. I would just give you the opportunity if you have any other thing to say or to share with us, Pierre.
Yes, there's something I should have included as well. The minister, when there is the process of approval and registration, he has to give his reasons in writing if it is that he rejects this proposal. So the person who's interested in developing their own condominium scheme, they would have a clear outline or an idea of what it is or the grounds upon which the minister or anybody or the body responsible, what they have relied on to reject or even accept the approval for the declaration and the description for the condominium scheme.
Okay, Miss.
Well, it's actually a component of the legislation that there are strict and stringent timelines placed on the executive, the minister responsible for housing, who is the person who these applications would have to be placed before. So apart from him having a time period of 3 months within which to accept, deny, or recommend amendments to what was submitted, being the declaration and the description instruments, he has to do that within the 3-month period. That had actually been in the old act, it was 6 months. So this new legislation really confines him to a time period. After that, if there is approval, then it goes onward for registration, and that registration is done at the registry, the respective registries under which the description of the property would fall under, either the deeds registry for unregistered areas of land and a transport, or by the land registry for land registration areas. And that process also of registering the condominium must not be more than 4 weeks. So in total, you can have approval within 4 months. And as Pierre highlighted, for any rejection or any denial by the minister, the Honorable Minister ought to furnish his reasons in writing so that it's clear what were the reasons for him making such a decision. So all I wanted to say in addition was that I now believe that this legislation has catered for the demands in housing. It has cured deficiencies of persons going to the commercial banks, and they can now do so freely, borrow against the unit, using the transport or the certificate of title as their proof of ownership and as collateral for a mortgage. And I believe that is most enticing, along with the other amazing amenities that condominiums offer.
Yes, indeed. So, thank you both for being here today. As I've mentioned at the beginning, this program is brought to you, the citizenry, by the Chambers of the Attorney General and the Ministry of Legal Affairs to enlighten and educate on laws that are being enacted. And this here, the Condominium Act of 2022, which we discussed today, is a very modern piece of legislation indeed, which takes into account a number of circumstances. And the legislation is pertinent given the juncture at which Guyana is right now and the trajectory on which it is headed, being one of the fastest growing economies in the world. So this act indeed stands out and is necessary and important at this time. So with that being said, this has been all of our time for today. Again, thank you, Pierre Squires and Miss Deborah Kumar, for being here with me. I am your host, Richard Beanie. Until next time, see you then.